I always deem it a great privilege to be with students in whatever capacity I could. I used to tell my friends that we older people, especially judges, have all the solutions even to new problems. But you students have new solutions even to old problems. Therefore, I always think that every visit of mine to an educational institution enlightens me more than the enlightenment that we could provide for the students. In fact, when Satyanadella was appointed as the chief executive officer of Microsoft, he wrote a letter to his colleagues. In the letter, he made a very interesting observation. He said, Microsoft, it's a software information technology industry. Satyanadella wrote to his colleagues saying, ours is an industry which respects innovation and not tradition. Just look at it. He said, ours is an industry which respects innovation and not tradition. When I read it, the thought that came to my mind was that I belong to an industry which respects only tradition and not innovation. Because we always refer to 1928 Privy Council, 1935 Madras, 1942 Bombay, 1950 Constitution Bill. So we respect tradition and not innovation. This is probably one of the ills or lacunae in our profession. As Justice Sundar pointed out, you children are really privileged to be part of a contemporary world where access to information and the infrastructure provided to you is so huge. In fact, I never participated in any moot court competition when I was in college. When somebody asked me about it, I said, moot was a moot question in our academic life. I never participated in one in Madras Law College because there were a lot of opportunities thrown to us in Madras Law College to entertain ourselves than to educate ourselves. When it came to a matter of choice between entertainment and education, I was not an youngster like you. I chose entertainment. You people have perhaps chosen education, and that is why where you have come, where you have come. The kind of infrastructure that your college has provided, it's unimaginable. You have air-conditioned halls, you have such auditoriums, none of which was present when we were in the law college. Therefore, you should feel lucky to be part of a world where everything is given to you on a platter and it's up to you to take it or leave it. As Justice Sundar pointed out, that all of you in the moot court competition performed very well. And in fact, we are not saying this as a matter of courtesy or as a matter of routine. As a matter of routine, wherever there is a competition, persons who are called upon to judge normally say, it was very difficult to choose and all that. That's a very formal expression of what they think or what they do not think. But that's not the way we put it. In fact, about winners and losers, Adolf Hitler said something very interesting. Hitler said, winners don't have to explain. Losers should not be there to explain. These are the two mantras that he adopted. Winners need not explain, and the losers should not be there to explain. That was his philosophy. Therefore, everything was about winning. But in the field of education, it's not about winning. In fact, today morning I had the person who introduced me pointed out I was in a different meeting. It was a meeting organized by Dinamani magazine where I had to talk. Something very interesting came up there. About 100 years ago, a poetry writing competition was conducted. 2 persons were selected. The first prize went to a person called Madhavaiya. Has anyone in this audience heard about Madhavaiya, a literary figure in Tamil? I do not think any one of you would have heard about Madhavayya. But a person who secured the second prize, if I tell you his name, all of you will know. The person who secured the second prize was none else than Subramania Bharati. Now you tell me, who was the winner, who was the loser? Madhavayya was the winner in that particular competition, but Subramania Bharati became the winner in life. When we announce the results, X may be the winner today, Y may be the loser today, but Y may turn out to be the winner later on. It all depends upon one's own destiny, one's own efforts, what you do in life, what you do with life and what you do in life, both are very important for us. Just two quick thoughts which I wanted to share with you when I heard arguments from both the teams. You must have noticed that we asked a very important question to the participants in today's moot court competition. All of them were talking about misconduct. We asked them, can a child be guilty of misconduct? The answer was, there is nothing on record to indicate the age of the child. There was nothing on, then we asked, what was the misconduct complaint of? They said, the moot court problem does not deal with, it is silent about the kind of misconduct. Is it true? I would like to read out two portions, give you a few dates and see whether that is right or wrong. I am going to tell you this for a purpose. If you look at the problem that was given to the participants in the moot court, you may see that the hero of the story, Adil, he entered into the country in the year 2000. In the year 2007, he gets married to Natasha. In the year 2011, the International State of Brigades in the state of radio was declared as a terrorist group in India. A few weeks before delivery of child, Adil sent his wife Natasha to radio. 2011. 2016, consequent to an internal conflict between armed forces and the rebellion groups in the Republic of Radio, the marginalized Champakam group started migrating to India, obviously with the intention of taking shelter. Thereafter, the child gets admitted to the school. Now, is this moot court problem silent totally about the age of the child, or is there sufficient indication in the moot court competition, in the moot court problem, for you to arrive at the age of the child? This is something that we wanted you to come up with. When we asked you, can a child be held guilty of misconduct? It is a very clever way of answering the question that there is no indication, the moot court problem is silent about the age. That's a good answer. But if there are indications in the moot court problem for you to find out the probable age of the child, the answer will be a clever answer but not a correct answer. Why I am telling you this is not really to find fault with any of the participants, but to tell you that what you should focus on is not merely law, but more of common sense. I can tell you one interesting incident that happened in the life of the great MC Settlewart. MC Settlewart, when he was one of the greatest lawyers in practicing in Bombay, one day very interesting incident took place. A young lawyer stood up in court to argue a case. Judge asked a question. He said something very offending to the judge, and the judge said, I initiate contempt of court against you right now. The young lawyer started shivering. The case got passed over. He said, I'll call the case in the afternoon, you will have to explain your conduct. When the young lawyer went totally perturbed, he met Settleward and cried. Settleward said, "Don't worry, I'll come and take care of you." Settleward came inside the court hall in the afternoon, and when the case was called, the youngster stood up, Settleward stood up. The judge was little surprised, and he asked Settleward, "Mr. Settleward, are you going to defend this young man?" he asked. Settleward said, "No, my lord, certainly not." This young lawyer got stopped. Settleward promised to defend me. Now he comes and says he is not going to defend my action. What is he going to do? Then the judge asked him, "Then why are you standing up when the case is called?" Then Settleward said, "My lord, I want to remind you only one thing, Lord. I am not defending the action of the youngster, but I want to tell you that after all, what this youngster did was, he did the right thing in the wrong way. When he reaches my age and your lordship's age, he will do the wrong thing in the right way." This is what Settleward said. And immediately the judge said, "Contempt discharged." When they came out, Settleward's junior told him, "Sir, now I realize the secret of your success." Settleward asked him, "What was the secret of my success?" The youngster said, "You know how to turn the same sentence back and forth. Probably judges get confused and they give you victory." Therefore, there are two morals to victory. One, you must have absolute clarity when you have an extraordinarily good case. Number two, you must have the ability to confuse when you have a very bad case. And how to confuse, I don't have to tell you. Your professor of contract law would have said. I don't know who is the professor of contract law in this college. You are the professor of contract law. I do not know how many of you have had the privilege of attending her class or knowing this. Please sit down, madam. A professor of contract law asked one of his students, "Suppose you were to give an orange to somebody, what will you tell him?" He said, "I give you this orange." Then the professor, he pulled up that student and said, "Talk like a lawyer. If you say, 'I give you this orange,' you talk like a layman, not like a lawyer." Then the student thought for a while and he said, "Yes sir, I will talk like a lawyer." He said, "If I want to give an orange to somebody, this is what I will tell him. I hereby give and convey to you, all and singular, my estate, interest, right, claim, title, advantages of, and in the said orange, together with all its rind, juice, pulp, seeds, and all rights and advantages, with full power to bite, cut, chew, freeze, and otherwise eat the same, or give the same away with or without the pulp, rind, juice, anything herein before or hereinafter done, notwithstanding what I have done earlier with the orange." So that's how our entire circle gets completed. Madam, I hope you have taught this lesson to all your students of contract law. What is more important for a lawyer is, first you must have a clarity of thought. Clarity of expression comes from your clarity of thought. But at the same time, you must be able to put things in a nutshell. I was told by a very learned member of the bar once upon a time how V.P. Raman presented a case in 2 sentences. It appears that there was a case before a single judge. The single judge decided the case on the basis of a division bench judgment. There were 2 difficulties. The division bench judgment was not applicable to the facts of this case. Added to that, the division bench judgment laid a proposition that was totally incorrect. The single judge dismissed a case on the basis of a division bench judgment. The division bench judgment did not apply to the facts of this case, and the division bench judgment was itself wrong for what it laid down. The whole briefing went on. The V.P. Raman stood up in court and said only one sentence: "My lord, a wrong application of a doubtful judgment." That one sentence whatever you could say in one paragraph was condensed into one sentence. He said, a wrong application of a doubtful judgment. Immediately stay was granted. Therefore, having clarity of thought, clarity of expression is an art in itself. These moot court competitions help you to perfect that art so that when you get into business, when you get into the profession, you will be able to become a successful lawyer. With these few words, I first congratulate the winners in today's competition. Then I congratulate persons who have lost today but who may turn out to be the winners in life. Thank you very much.
Truer words have not been spoken. If you can't convince them, confuse them. I thank you, Your Lordship, for your encouraging words and giving us all a glimpse of what an eloquent speaker you truly are. It is an honor having you both in our midst. And now it's the time everybody has been eagerly waiting for, the results. Before that, I will be giving out the participating certificates. Okay, so I'll call you one by one, and please make sure you enter on my right and exit on my left, so that there's no confusion. Thank you. RJ001, KIIT Bhubaneswar. Guys, give them a round of applause. Honorable Justice M. Sundar, if I could request you to please. Thank you so much. RJ002, GLC Ernakulam. RJ004, QSAT Cochin. RJ004, QSAT Cochin. RJ005, Amity Law School, Delhi. RJ006, Wales University. RJ007, VIT Chennai. RJ008, NUJS Kolkata. RJ009, GLC Thiruvananthapuram. RJ10, Bharat Law University. RJ11, KL University, Andhra Pradesh. RJ12, Shastra University, Tamil Nadu. RJ13, Alliance Law College, Bangalore. May I now request Honorable Justice P. Ramasubramanian to take over? Thank you, Your Lord. RJ15, RGNLU, Punjab. RJ16, Symbiosis, Pune. RJ17, Karnataka University. RJ20, GLC, Chengalpet. RJ21, GLC, Dharmapuri. RJ22, Savita Law College, Chennai. RJ23, New Law College, BVP, Pune. Please give them a big round of applause. And now for the results of the finals. I will start by saying the best memorial. The runner-up for the best memorial is RJ003 Christ, Bangalore. Your Lordship, it would be an honor to have you both actually presented to them. And the best memorial goes to RJ007 VIT, Chennai. I will now announce the best speaker. The runner-up speaker is RJ007 Rohit Alex Abraham, VIT, Chennai. And the best speaker goes to RJ14 M Aisha, GLC, Chennai. I'll now be announcing the researcher's winner. The runner-up researcher is RJ004, Sanat Joe Cusack Cochin. And the best researcher is AS Arvind, GLC Chennai. And now the award that people have been most looking forward to. The second runner-up, RJ014, GLC Chennai. And the winner, ladies and gentlemen, hold your breath, for the third annual National Moot Court Rationibus Jure National Moot Court Competition is School of Excellence! And the runner-ups, Christ University, Bangalore. Congratulations to all the winners and participants. Please give them a round of applause. I now invite Mrs. Brinda Karthikeyan, Assistant Professor and Moot Court Convener of SRM School of Law, to deliver the vote of thanks.